Morning, Wakili. My name is Fatuma Zichale, Judge of the Court of Appeal and Commissioner, Judicial Service Commission.
Thank you, my lady.
Morning, my name is Charity Kisotu, a commissioner, and welcome.
Thank you, Commissioner.
Isaac Ruto is my name, member of the JSC.
Thank you, Commissioner.
Good morning. My name is Nzilani Caroline. I'm a commissioner. Welcome.
Thank you.
Good morning, David Majanja, Judge and Commissioner. Welcome.
Thank you, my lord.
Thank you very much, Commissioners. We will now start the interview, and I will ask Mr. Mwamuye to begin by confirming your county.
My home county is Kilifi County.
Your ethnicity.
I am Mijikenda.
The commissioners will engage you with the questions. We have looked at your CV and your sample writing and all the documents you have sent, but we will engage you with a few questions. And the first set of questions will be asked by Justice Ishara.
Thank you, my lady.
Thank you, Honorable Chair. Wakili, looking at your CV, it would appear like you now have slightly over 15 years of experience ever since you were admitted. Is that correct?
That's correct, my lady.
Right. And majorly you've been in private practice.
Yes, that's correct, my lady.
Right. Now, we have about 100 candidates, actually to be specific, 100 candidates, whom we are interviewing for the position of judgeship in the High Court. Can you tell us, say in 3 minutes, what you've been doing ever since you qualified that makes you think you are the right person that we should take for the position of High Court judge?
Thank you, my lady. For the position of High Court judge, I believe the Commission wants to see certain attributes such as professional competence, good judgment, diligence, and the ability to work well with others, amongst others. I began my career in the Kenya Revenue Authority in 2007. I was a revenue officer, and I eventually transferred to the Legal Services Department, where I was a legal officer. During that time in the public sector, I acquired certain skills. The role of revenue officer and legal officer also had some administrative and managerial roles. So I was able to garner this experience, and then I transitioned that into the private sector from 2012 to date. Aside from running a law firm, I've also held positions in statutory and in statutory and constitutional tribunals, which I believe have prepared me for the role of Judge of the High Court. I am familiar with writing rulings and judgments during my stint at the National Environment Tribunal from 2016 until 2023, and at the constitutional tribunals, I'm well versed with the expectations of a judge.
Thank you for that. So if you are to be the lucky candidate and you are taken as a judge of the High Court, what is it that you would want to do differently from what you've generally observed happening in the judiciary when it comes to judgeship?
Thank you, my lady. There are two things that I've noticed about how certain matters are conducted in the High Court. The first is delay. What I would propose to do is I'd make more use of extempore rulings for straightforward matters, rather than having to retreat and write for 14 days or so and then deliver those rulings. Delay can also be mitigated by making better use of ICT, such that instead of having to handwrite something and then have someone else type it, or perhaps yourself type it. You type whatever it is that you're doing directly into the computer. The other issue that I've noted that I would do differently is how we project the image of the judiciary to the public. It's a small thing, but where a court does not start on time and an explanation or an apology is not preferred, that sends a very negative picture to the public. As advocates, we understand that life happens and sometimes a judge is called at the last minute into a meeting, but our clients are not that familiar with these processes, and so I would do that differently.
So that is as far as the negative aspects are concerned, but I'm sure it's also possible that there are one or two things, if not more, that you would like to emulate from what you've seen happening in the judiciary, particularly when it comes to judgeship, and possibly you could tell us if there are judges that you admire, the way they conduct themselves, etc.
Thank you, my lady. When I began practice in 2008, we had a very, very different judiciary. It was not uncommon for judges to be overly strict and sometimes maybe even unfair. But I'm happy to say that we have had a lot of progress, a lot of transformation, and this is seen in how the values of humility and courtesy are integral to the role of a judge now. There are a number of judges that I admire. Some of them are in this room. What I admire most about them is their diligence, their calmness, the way they are methodical in handling their briefs, and also particularly when I used to appear before Justice Majanja at the beginning of my career, how Justice Majanja would mentor me and show me that I have to do things in a particular way. There was one case where I asked for 14 days to put in a replying affidavit, and Justice Majanja said, no, you can't do that. You can file something by the afternoon. And that encouraged me to go back to the office, get the officers, have an affidavit drafted, signed, commissioned, and filed.
Thank you, and that's so much from me, but just a little issue, and I hope you don't mind me asking you this. When you say you are a Mijikenda, which particular subsector of the Mijikenda are you? Giriama?
I'm a Chonyi, my lady.
Chonyi, okay.
I'm a Chonyi, my lady.
Thank you.
Okay, thank you. Just a few questions. The first one is, this is the second time you've appeared before us. You were here last time, and as a feedback, actually you did very well. It's only that the positions were few. It was not because of, any lack of skills. You performed exceptionally well. Now, what is driving you? Because there has to be something that is driving you into wanting to cross over to the judiciary by appearing the second time. You didn't lose hope. You still thought it was good to give it a shot a second time.
Becoming a judge is a calling that I feel very personally. It's been a dream that I've had for as long as I can remember, and it's informed all the educational and career choices that I've made. My approach to setbacks is not to let them overcome me. It is to redouble my efforts and come back strong, and hopefully my application is even better than last time.
From when I look at your CV, based on the various areas that you've served, would you demonstrate to the Commission what are the key attributes that you think you've garnered, in terms of experience that makes you judge ready, in the sense that if you are given this appointment, the learning curve will not be long?
Thank you, Vice Chair. From my sample writings, I believe I demonstrate that I've had a wide practice in different superior courts as well as before tribunals, as well as experience in writing rulings and judgments. My fifth sample writing is a decision of the National Environment Tribunal in which I was the acting chair. I conducted all the proceedings, and after conferencing with my two colleagues in the matter, I wrote the entire judgment. So I believe that demonstrates that I'm judge ready.
Now, my final question. You know, in the process of recruitment, even for us as a commission, sometimes it's not easy to, you know, to say with reasonable measure of certainty that the person you are going to give that appointment will be able to pass the muster once it comes to doing the actual job. It's kind of sometimes a hit and miss. We get it right many times. Also, sometimes we get it wrong. Now, what would you say that you have now as Bahati Mwamwe that would give us some confidence that the moment we say that we are going to forward your name for appointment as a judge, that will be among the pool of those ones that we can say that we got it right as a commission? Three key things.
Thank you, Vice Chair. Three key things on that. First, I've demonstrated my ability to deliver in high-profile, high-pressure situations, both in statutory and constitutional tribunals. Secondly, I believe in continuous learning and improvement. The judge I will be, God willing, in 2024 will not be the judge that I will be at 70 when I'm retiring. This requires you to have an open heart, an open mind, humility. If you need to ask someone for advice, consultation, that is something I do on a daily basis. Lastly, it is about integrity. I have served in places that have been profiled about having some integrity issues, but I have discharged myself very well in those areas, and there has never been any integrity question to my name, and there never will be.
Yes, following on those questions my colleagues have asked, I will want to go straight to the High Court, which, as you know, has various jurisdictions. In fact, when we met stakeholders to prepare for this interview, they told us there are about 12 or 13 jurisdictions of the High Court. If you can tell us about 5 of them, the jurisdictions of the High Court.
Thank you, my lady. The High Court has unlimited original jurisdiction in criminal and civil matters. It has a supervisory jurisdiction over subordinate courts and public bodies exercising quasi-judicial roles. It has appellate jurisdiction over constitutional tribunals for the removal of office holders other than the president and judges of superior courts. It has jurisdiction to interpret the Constitution and apply the same to statute. It also has the jurisdiction to investigate whether the Bill of Rights is threatened, infringed, violated, or in any other way being contravened.
Thank you. A survey was done on the judiciary sometimes regarding access to justice by the members of the public. And the survey revealed that only 10% of Kenyans are able to access formal justice systems, the magistrates' courts, the High Court, Court of Appeal, and the Supreme Court, meaning that a huge segment is left on their own devices. As a judge, what would you do to make sure that we broaden the doorways to justice?
Thank you, my lady. As a judge, I will promote the multi-door approach. It requires the recognition that the formal justice system may be too expensive or too inaccessible for most Kenyans, and aspects like conciliation, mediation, whether court annexed or not, alternative dispute resolution, or even alternative justice systems at the community level may be a better and more accessible way of obtaining justice.
Thank you. Now, straight to the Constitution. As a High Court judge, cases might come your way if you are successful in this venture to become a judge, challenging the constitutional validity of a statute. Just tell us what principles will guide you in determining whether that statute is valid.
Thank you, my lady. I'll be guided by the Constitution and the pronouncement of superior courts on what constitutes an invalid statute. The first is that the statute or the applicable provisions within it are unclear, ambiguous, or not capable of interpretation. For example, the Court of Appeal applied that standard to the definition of robbery with violence, looking at whether it was very clear what constitutes robbery with violence. Another is a process examination, examining whether it is a matter that required both houses of parliament to pass it, but it was only passed by one house of parliament. That would be an invalid statute. Third is on public participation. Quite a number of statutes have been invalidated because they do not meet our public participation requirements. The fourth is that it derogates from the essential nature of a fundamental right of freedom in a way that is not contemplated by Article 24. And lastly, it is something that grossly contravenes a specific provision of the Constitution.
Thank you. I think I'm happy with that. The next set of questions will be asked by Justice Majanja.
Thank you, my lady.
Last time you were here, you recall one of the commissioners took you through what happened at the Net Tribunal, the issue you had with the chair at that particular time.
Yes, my lord.
And I'm sure you've had time to reflect on what happened.
Yes, my lord.
What lessons do you draw from that experience? Perhaps you tell us what happened, and then what lessons do you draw from that experience that would be relevant to you as a judge if you're appointed?
Thank you, my lord. There was an internal breakdown within the National Environment Tribunal at the time when the then chairperson, the Honorable Dr. Dwasi, was coming up for renewal. Myself and my colleagues had some concerns about her conduct as the chairperson. In my exchange last time with Justice Wasame, he was able to make me realize that I did not fully exhaust the internal mechanisms that were available to me, and we rushed to the JSC. I should have gone to Dr. Dwasi, explained my concerns to her, given her an opportunity to respond before coming to this commission. It is something that I learned, I regret. I did apologize. I sent her an apology email. I didn't have her telephone number, and it's something that will not happen again.
Okay, that's good. At NET, one of you were writing judgments. What were some of the challenges you faced in writing judgments, and are there any lessons learned that would assist you in this job you're applying for?
At NET, our biggest challenge, my lord, was that unlike what is in the mainstream judiciary, we would not have documents in soft copy. Environment cases at the National Environment Tribunal level are often very complex, and it's not uncommon to have 10, 20 volumes of reports. So what we had to do is to go through all of those reports. We had to learn how to leverage on our skills. What I did for the matters where I would be asked to write is I found out that we have software that you can scan the bundles, turns it into a Word document, which makes it easier for you to copy things and put them into your final judgment.
Okay. And finally, away from the two questions I've asked, can you tell us the difference between appeal and revision in the context of the Criminal Procedure Code? The difference between an appeal and a revision.
Thank you, my lord. A revision is where the Superior Court, in this case the High Court, is looking for an error manifest on the record. It is different from an appeal, which is looking at the merits as well as the law on the decision. There are certain things you can do in an appeal that you cannot do in a revision. For example, you cannot revise an acquittal into a conviction. But on appeal, you can vary the sentence, you can enhance the sentence, you can reverse an acquittal into a conviction.
And how is revision invoked or exercised?
It used to be that the judge would go over records and then revise. But now we apply for revision.
You can apply, you can go over records. Party can apply to you. And for example, if you saw you were sitting in Machakos and there was an